Well, good afternoon. Thank you so much for joining us and for staying from the previous session on arbitration. For those of you who are new to the audience and for the recording, my name is Chanel Schuyler. I'm the Director of ACAP and Intake at the Florida Bar. And this is the Florida Bar's mediation training. This training is CLE and CME approved for 2 hours of general credit and I believe also an ethics credit for CME. So this program is presented by the Florida Bar Standing Committee on Grievance Mediation and Fee Arbitration in conjunction with the Alternative Dispute Resolution section. I'd like to thank the members of the section and particularly the officers, members for promoting this training today. I'd also like to thank the members of our Standing Committee who had a vision for this program and this training and who have brought it to fruition today. For those of you who were in the last session, this is just kind of an overview of the general program of the Florida Bar. As a primer on the history, it's helpful to understand that most grievances that are filed against attorneys have an element of a fee dispute. In fact, that's usually the main topic in grievances. And unless the fee dispute is clearly excessive, illegal, or extortionate, the Supreme Court of Florida has held that fee disputes are civil matters between attorneys and clients. So before 2004, each circuit had its own mediation program. However, in 2004, the Florida Supreme Court amended the rules regulating the Florida Bar and created Chapter 14, which combined the two alternative dispute resolution programs into one program centrally processed. So now when parties consent to participate in the program by either their written fee agreement or by a consent form that we send to them, we engage volunteer mediators and arbitrators from around the state to handle those matters. The program, like the arbitration program before that we just talked about, it has some nuances, so there are times when things will have to be adjusted for the mediation, just like there was in the arbitration program that we just discussed. So I have the pleasure of introducing you to our trainer today, Charles Castagna. Charles is a native of Clearwater, Florida. He began his legal career in 1980 as a law clerk for Florida Supreme Court Justice James C. Adkins, Jr. in Tallahassee. He graduated from George Washington University in 1977 with a degree in public affairs, and he received his JD from Florida State University, go Noles. Can you tell where my loyalties lie? Mr. Castagna began mediating in 1988 as a volunteer with the Sixth Circuit Citizen Dispute Settlement Program. He is certified as a circuit civil and county mediator in 1990 and as a family and federal mediator in 1992. He has now mediated more than 3,500 matters in state and federal court, as well as pre-suit, including civil rights, commercial, condominium, construction, contract, corporate, and employment and non-compete clauses, family law, all issues, franchise disputes, hurricane claims, insurance coverage and bad faith, personal injury and wrongful death, premises and product liability, probate, professional liability, accounting, dental, legal, medical, and real estate and securities laws. He's won numerous awards and he is now the current chair of MEAC, is that correct?
No, Immediate Past.
I'm sorry, Immediate Past, excuse me. And so please help me welcome Charles to be our trainer today.
Thank you, Chanel. And to you and your staff for putting on this program, and to Gary and his subcommittee for getting this thing all put together as well. It's an honor and a privilege to be here with you all this afternoon to talk about mediation. And thank you to Louise. Is Louise still here? Yes. She called me last July and asked if I would be interested in talking about mediation. I said, Louise, I'm always interested in talking about mediation. So I appreciate that phone call, and I'm happy to be here. So here's how we're going to use the 2 hours that we've got for this segment of the program. From now until about 4:30, we're going to talk about Chapter 44 of the Florida statutes, the Mediation Confidentiality and Privilege Act. We're going to talk about the Florida rules for certified and court-appointed mediators. as many of them as we can get through in that time frame. Then from 4:30 to 5, we're going to talk about the Florida bar rules and procedures dealing with this grievance mediation program, as well as best practices and procedures. And then from 5 until 5:30, we'll have another role play based on the same basic set of facts that you all saw role played in the arbitration setting. Adam Myron and Sandy Myers will be the attorney and client again for that, so they're back for a repeat performance. A little bit of a different setting, though. It'll be a good illustration of the difference between arbitration and mediation. It is my typical style of presenting to invite comments and questions throughout. So you don't need to wait until the end to ask them. We may not have a whole lot of time then anyway. Just get Chanel's attention. She'll get a microphone to you as we're proceeding through this, and we'll be able to address things as we go along. All right, so let's get started. Chapter 44, Florida statutes. The first thing I want to touch on is something near and dear to all of our hearts. Section 44-107, immunity for arbitrators, mediators, and mediator trainees. And the statute basically provides that arbitrators serving under this section, as well as mediators and trainees fulfilling the mentorship requirements, shall have judicial immunity in the same manner and to the same extent as a judge. So that's a pretty good grant of immunity. It's not absolute immunity like you get when you're serving in a grievance hearing capacity. That's a higher level of immunity, but judicial immunity in the same manner and to the same extent as a judge is a pretty good grant. An interesting note, though, is the second paragraph of that statute provides that a person serving as a mediator in any non-court-ordered mediation, which this would probably be. These are not going to be court-ordered mediations that you all are going to be conducting. In those mediations, and it also might be pre-suit or another matter that's in litigation, but that the court has not ordered to mediate, but that the parties have agreed to mediate. So those are the circumstances under which you could have a non-court-ordered mediation. In that setting, a mediator shall have immunity from liability arising from the performance of that person's duties while acting within the scope of the mediation function. So it's a different grant of immunity, and we're not going to get into and drill down on the differences of, whether it's court-ordered or not court-ordered, and it looks to me like judicial immunity is better than what you get in a non-court-ordered setting, but that's really a discussion and a topic for another day. That's just the way the statute reads, and you can interpret it as you will and reach your own conclusions as to what that means. The next thing I want to touch on, 44.401, is the Mediation Confidentiality and Privilege Act, and we will talk about it's very broad in scope. Just so you know, in general, the scope of the statute is, except as otherwise provided, this statute applies to any mediation required by statute, court rule, agency rule, or order, oral or written case-specific order, or court administrative order, or by any mediation conducted under this chapter by express agreement of the parties or facilitated by a certified mediator. So the way the statute reads now, if you're a certified mediator, that basically brings the statutory confidentiality to that process. So it's a much broader grant of confidentiality than existed before this statute was amended. Gosh, I think it was back in 2004, 2008. It was some number of years ago. There's a definition section, which we're not going to spend a whole lot of time with, but it talks about mediation communication, mediation participants. I do want to talk about the definition of a mediator, which is in that section. A mediator is defined under the statute as a neutral, impartial third person who facilitates the mediation process. The mediator's role is to reduce obstacles to communication, assist in identifying issues, explore alternatives, and otherwise facilitate voluntary agreements to resolve disputes without prescribing what the resolution should be. So diametrically opposed to what an arbitrator ultimately does, which is makes a decision. mediator does all of these other things, identify issues, exploring alternatives, and basically does what he or she can to get the parties to reach an agreement. Hopefully they do. Statistically speaking, more often than not they do, but sometimes they don't. And that's what courts are for, or other forms. Again, we're not necessarily going from the grievance mediation to court, obviously, but whatever, if it doesn't get resolved in mediation, there'll be another disciplinary mechanism that does come into play, and obviously in whatever that is, it's not going to be where the parties have the right to decide the outcome. And that's the big difference, and that's frankly a big advantage of mediation, and one that I do my best to stress to the parties is the self-determination, the opportunity to basically have 100% control over what happens versus turning it over to an arbitrator, a judge, a special master, whoever is going to be making some other ultimate determination. The duration of mediation is also defined by statute, and a court-ordered mediation begins when an order is issued by the court. And very briefly, the way that it operates in Florida, the court orders, other than in federal court, in state court, the court orders typically provide that the parties have 10 days within which to select a mediator. So even before the mediator is selected, statutorily, the mediation confidentiality, the mediation process has begun, and therefore there is that umbrella of confidentiality that comes over the process, even before you have a mediator. In all other mediations, the mediation begins when the parties agree to mediate, or as required by agency rule, agency order, statute, etc. So once the parties agree to mediate, again, under the statute, the mediation has begun, and the confidentiality would again apply at that time. Confidentiality, privilege, and exceptions are set forth in Section 405 of Chapter 44, and there are 6. Except as provided in this section. And by the way, this is an important thing. So when someone says, a mediator, for instance, in an opening statement, that mediation is confidential, it's very important that the parties and the participants understand that it's confidential except as required or permitted under Florida law, because there are 6 exceptions, and we'll go through them here in just a moment. So except provided in this section, all mediation communications shall be confidential. A mediation participant shall not disclose a mediation communication to a person other than another mediation participant or a participant's counsel. And a violation of this section may be remedied as provided in Section 44406, which is a civil remedies provision. So there are some teeth to the confidentiality rules now, and briefly I'll just jump over to that. In 44406, that section provides that any mediation participant who knowingly and willfully discloses a mediation communication in violation of this section shall, upon application by any party to a court of competent jurisdiction, be subject to remedies including equitable relief, compensatory damages, attorney's fees, mediator's fees, and costs incurred in the mediation, as well as reasonable attorney's fees and costs incurred in the application for remedies under this section. So there's some teeth to the confidentiality. It's important that you all, that mediators understand that and convey that to the parties, because hopefully what happened to the parties in the Gulliver case down in South Florida, I don't know if y'all are familiar with this or not. Anybody? The Gulliver case was a headmaster at a private school. There was a mediation. The headmaster's daughter apparently had 1,200 Facebook friends to whom she communicated how well the mediation went, and in fact that Gulliver was paying for their summer vacation with an $84,000 settlement. The district court, I don't remember if it was a trial court and then it was appealed, but in any event, the settlement was thrown out as a result of that breach of confidentiality. So I imagine her folks weren't very happy, and it's just good to know that the confidentiality is taken seriously, and civil remedies can be rather oppressive, depending on which side of the fence you're on with that. So the exceptions, very briefly, Number one, first of all, an agreement reached in mediation is not confidential unless the parties agree to make it so. So it's not confidential simply because it happened in mediation and the parties wrote it up and there's a mediation agreement. There has to be the parties agree that the terms of this mediation or whatever language the parties decide on, making it confidential. But as far as the specific exceptions, number one, waiver. Obviously, the parties can waive confidentiality. Number two, any communication that is willfully used to plan a crime, commit or attempt to commit a crime, conceal ongoing criminal activity, or threaten violence. Those are not confidential, those communications. Number three, anything requiring a mandatory report pursuant to chapters 39 or 415, child abuse and vulnerable adult abuse, again, under Florida law, must be reported, period. So that if it comes up in mediation or not, it's an exception to confidentiality and it must be reported. And again, solely for the purpose of making the mandatory report. So that's the only reason or the only purpose for which those communications can be used, but they are not strictly and absolutely confidential. This is one of my favorites, and I personally do not, and I don't list any of these, by the way, in my opening statement, and I think you'll appreciate that, especially if you're an attorney representing a client in a mediation. But the fourth exception is anything offered to report, prove, or disprove professional malpractice occurring during the mediation solely for the purpose of the professional malpractice proceeding. You don't get along with lawyers real well if you're telling their clients in the mediation that, oh, by the way, if your lawyer commits malpractice, it's not confidential, and you or I can report him under this exception. Number five, offered for the limited purpose of establishing or refuting legally recognized grounds for voiding or reforming a settlement agreement reached during mediation. So if there's fraud, if there's the duress, if there's the absence of bargaining ability, and there's a case, we're not going to be able to get into it now, but I'll give you the site and the case name. It's Valsheen versus Valsheen. I would encourage you to take a look at it because it lays out, basically the court's inherent authority. The Fourth DCA has made the ruling in this case to set aside a mediation agreement reached under fraud, duress, or substantial violation of the mediator's standards of conduct. So Valsheen is 793 Southern 2nd, 1094, 793 Southern 2nd, 1094. Worth taking a look at. And then finally, offered to report, prove, or disprove professional misconduct occurring during the mediation solely for the internal use of the body conducting the investigation of the conduct. And again, when you look closely at this statute, the language is very broad. It's report, prove, or disprove. So you don't have to just be subpoenaed in order to testify. You can initiate a report insofar as the statute is concerned, if that's the appropriate or required thing to do. So moving quickly here, what questions, comments, if any, on Chapter 44? We good? One over here? Oh, wait for the mic. We've got another audience that we're...
Did you say that unless you put in the document confidentiality, it's not going to be, it's subject to being looked at?
Under Chapter 44, that's correct.
Even though the chapter says all mediations are confidential?
Well, the mediation is. The agreement itself is not unless the parties agree to make it so. So it's a little bit of a kind of a windy road to get there. You can make it confidential if the parties agree. And typically what happens is when someone says, I want confidentiality, someone else says, well, how much do you want to pay for it? And so it becomes another negotiating point. But that's fine. I mean, there's nothing wrong with that, but it's not automatic to your question. Anything else? We good to move on? All right, let's look at some of the rules, which I think Chanel provided via email to y'all, a PDF document. So if you have those, you can refer to them. If not, it's easy enough to look them up after the presentation. So the scope and purpose rule is the first one I want to touch on, and that is 10.200. And it basically provides that these rules provide ethical standards of conduct for certified and court-appointed mediators. These mediators are selected by the parties or appointed by the court. The rules are intended to both guide mediators in the performance of their services and instill public confidence. And this is something that the bar does with I think, a lot of its rules as well, in terms of trying to, instill public confidence in the process, in legal proceedings, legal representation, et cetera. So here they want to instill public confidence in the mediation process. The public's use, understanding, and satisfaction with mediation can only be achieved if the mediators embrace the highest ethical principles. Now, this is the kicker, and this is an important part. Not so much in Florida bar, so I don't want to drill down on it too far, but it's important to know. Whether the parties involved in a mediation choose to resolve their dispute is secondary in importance to whether the mediator conducts the mediation in accordance with these ethical standards. And there's a lot of debate about that in terms of how far mediators should go and how hard they can push and what they can do and can't do and all of that. And we're not going to dwell on it. We don't have the time to dwell on that at great length now. But just understand that the people, the committees, the DRC, which is basically an arm or a branch of the Florida Supreme Court, which is in charge of the discipline of mediators, their attitude is that it's more important that you do the process the way it's designed and supposed to be done in Florida than that you reach an agreement. And, that makes sense to me. I think there are a lot of good reasons for it. And I'll just say in a nutshell, when you read through these rules, you've got plenty of leeway to do what you need to do, to be an effective mediator, to work the process, to be very proactive, not a wallflower, not just throwing numbers back and forth or doing what a lot of people criticize of some mediators. There's a lot more room, and we'll touch on some of the rules that open the doors, I think, to a more active approach by the mediator, but still within the standards of conduct. So that's the scope and purpose rule. The next one I want to touch on is the role of the mediator, Rule 10.220. The role of the mediator is to reduce obstacles to communication, to assist in the identification of issues and exploration of alternatives, and otherwise facilitate voluntary agreements resolving the dispute. The ultimate decision-making authority, however, rests solely with the parties. And again, a clear distinction, totally diametrically opposed to an arbitration or a litigated outcome for that matter. Here, it's really entirely up to the parties. So the mediator's job, again, in Florida, they use the word facilitate here. Florida is a facilitative model where you're not, and again, I don't want to dwell too much or delve into the differences between facilitative and evaluative mediation. That's, again, a subject for another discussion in another day. But in Florida, it's about facilitation. It's about recognizing the decision-making authority being 100% in the parties' hands. And the concepts that are outlined in 10.230 of mediation in Florida are concepts of communication, negotiation, facilitation, and problem solving that emphasize self-determination, the needs and interests of the parties, fairness, procedural flexibility, confidentiality, and full disclosure. So again, you get the gist from that, from the concepts as they are defined in the Florida rules, that it's a process to be flexible, to give the parties the opportunity to talk, to listen, to try to work things out. Fairness is, from where I sit, in the mind, in the eyes of the beholder, in the eyes of the parties. It's not for me to say this is a fair outcome or not. Because how do you maintain impartiality when you're weighing in on the fairness like that? Because the party that agrees with you think, yeah, see, the mediator thinks it's fair, and the other party who maybe doesn't, you can see where that goes and how problematic that can become. But fairness is up to the parties. And sometimes they may think something's fair that I think is not fair. And I hope I don't telegraph that. I don't believe I do. I certainly shouldn't. And I would never, and it would never be appropriate for a mediator to say that out loud. Or to communicate it, frankly, in any way. All right, Rule 10.300 talks about the mediator's responsibility to the parties, and there it talks about the purpose of mediation is to provide a forum for consensual dispute resolution by the parties. And sometimes you'll hear, well, the court ordered me to be here, or again, in the Florida bar setting, I'm here because there's this potential grievance. So it's really not consensual. Well, the idea of the consensual nature of it means this. While you may be ordered or pressured, or, the Florida bar says, go mediate if you want to, try to work this out without us getting involved from the disciplinary angle, the consensual part of it is you don't have to settle. You don't have to agree. You just have to try. And so that's obviously what the mediator is there to help the parties with and what the parties are there to do. But it's not necessarily that you're there because you thought it would be a good idea or you wanted even necessarily to be there. So it goes on to say that accordingly, first of all, it says that it's not an adjudicatory procedure, again, distinguishing it from arbitration and litigation. Accordingly, a mediator's responsibility to the parties includes honoring their right of self-determination, acting with impartiality, which is absolutely critical to the effective mediation of a case, avoiding coercion, improper influence, and conflicts of interest. A mediator is also responsible for maintaining an appropriate demeanor, preserving confidentiality, and promoting awareness by the parties of the interests of non-participating persons. So they're covering a lot of things here, and the rules drill down in terms of more specificity as to what each of those means. And finally, and this is again just sort of an overview segment, talking about the general responsibilities that mediators have to the parties, that a mediator's business practices should reflect fairness, integrity, and impartiality. Right. Any questions, comments, anything so far? All right. 10.310 talks about self-determination, decision-making. Decisions made during a mediation are to be made by the parties. A mediator shall not make substantive decisions for any party. A mediator is responsible for assisting the parties in reaching informed and voluntary decisions while protecting their right of self-determination. I mean, this is it's a hallmark in Florida. It's really what the process is all about in Florida, is self-determination and the, obviously informed and voluntary decisions. And anytime someone says, I have no choice, I've got to do this, as a mediator, you ought to be paying attention and finding out, wait, hold it, time out, let's talk about that. You absolutely don't have to do this in mediation, at least insofar as the process. Now, you may have reasons that you feel you really want to do it, and maybe you have reasons you feel that you have to do it, but I'm not here as the mediator, and the process is certainly not requiring that anyone reach any agreement at all. Again, we all hope that is the outcome, but not in a coercive sense at all. In fact, the next point is coercion is prohibited. A mediator shall not coerce or improperly influence any party to make a decision or unwillingly participate in a mediation. So if someone says, I'm done, I think you have a very short leash, a very limited amount of time to explore. Do you need a break? Are you tired? Is there something we can further talk about? If they say, read my lips, I'm done, I don't want to be here anymore, I think the mediation's over. That's my reading of this. Misrepresentation is, of course, prohibited. A mediator shall not intentionally or knowingly misrepresent any material fact or circumstance in the course of conducting a mediation. And then postponement or cancellation. If for any reason a party is unable to freely exercise self-determination, a mediator shall cancel or postpone. So again, if you observe, and this is a very subjective decision on your part, if you observe that someone is tired or, maybe they're taking medications or in some other way unable to participate in the process, you need to do something about it. And now the question only is, do I adjourn or do I terminate? And to adjourn, which is basically a continuance, let's call it a day. We've made some good progress. You want to try to spin it as positively as you can. I think we're going to all be better off coming back tomorrow, next week at some mutually agreed upon time, whatever they agree to. Or if it's the kind of circumstance where it's not going to get any better tomorrow or next week or next month, then it may just be a termination, which simply means that you're reporting to whoever you're reporting it to that no agreement was reached. And by the way, the report is not a confidential document. When a mediation is concluded, if it's not pre-suit, if it's with the Florida Bar, I presume there's some report that needs to be done. And if it's in circuit civil or in federal court, the court wants to know basically who is there: plaintiff, defendant, plaintiff's counsel, defense counsel, insurance reps, whoever they were. How long did they mediate? And was there an agreement? Was there no agreement? Was there a continuance? Those types of very general things. And there are just some pretty uniform forms that are each circuit and district has their own forms in that regard about what you are to report, but it's very limited. Certainly nothing about what was said or done or negotiated in the confidential mediation process. So, yes. Can we get a mic over to Carmine? Oops, do we have a mic? Oh, I see it over there. There we go, thank you.
Particularly in regards to family mediation, to begin with, and over the years that I've done it, I try not to let the matter go beyond 2 to 3 hours. And you have complex, highly emotionally charged cases. Sometimes it takes the first 2 or 3 hours, or maybe even into a second session, to get through the emotions and the attitudes, all of which during the process, in my own shorthand way, I'm taking down issues that I will then feed back to them in some sort of a neutral or mutual fashion. I found that if people work beyond that, then they get frustrated, they get tired, and maybe agree to things they're not happy with. The idea being to look for a natural breaking point where we come up with something to where it may require some homework or a trial balloon or some activity that they can work on for a period of time, so it gives you the natural transition to break from now and to come back later with some sort of a report and some sort of a success story, or at least some things that they've been able to figure out so they can move forward. So they kind of look for that natural bridge for the break to the next level.
I think the idea of, and especially if on the front end you've scheduled it for 2 or 3 hours, that sort of gives you almost an automatic, because sometimes if you just leave it open-ended and the parties are there and everyone wants to kind of push on, and it makes it a lot tougher, and that can be a real problem.
Well, and then I think that's one thing that goes along with maybe a little bit of experience as well, because I have lawyers say that, well, we want to reserve the day, and I'll say, time out, here's what we're going to do. We're going to start off with this window of time. We'll see how things go, and take control as the mediator of what the process is going to be. They're obviously going to have the opportunity to have the process work for them, but we have to have some modicum of control so that we know it doesn't get out of hand and then we lose them later on by falling apart. So
that's a really good point, and that can happen, and it's something you want to, and you have an obligation. It's not that you just want to be aware of it. I think you've got an obligation. Because the durability of the agreement is an important thing too. And if somebody's coming in hours or days or weeks after the mediation saying, the mediator made me stay, I was exhausted, I was hungry, I didn't have my meds, whatever it is, you're going to have problems. So I think that's certainly one way to address those proactively on the front end. Thank you. So one of the things Mia touched on and toward the end of her presentation was a MEAC opinion, which, by the way, MEAC opinions, and I was on the MEAC for 8 years, but nevertheless, it doesn't change what I'm about to say. They're opinions. It's not rules, it's not law, it's not anything other than the opinion of 9 mediators that from each of the northern, middle, and southern divisions that say this is what we think to the answer to the specific question that was asked is. And so it's helpful, and that's what they're intended for, and that's what the MEAC is there for, is to provide guidance to mediators. But it's not like this is the rule, because people, and I do these CME classes routinely, people disagree sometimes loudly with what the MEAC has opined. And unless there's been some other ruling from some body that has jurisdiction and authority to reinterpret or interpret the rules, then it's the opinion of 9 people. And again, I think it's a helpful thing to be able to look at and refer to, but it's not like that's the law of mediation or that it has even the same level of control over our practice as the rules and standards do. But they're there. You can find them on, if you haven't already, flcourts.org. There's a whole index of every single one that's been published since, the beginning of, I think the late 90s is when they started issuing those opinions. So anyway, the MEAC opinion says that an arbitrator cannot mediate a case, or should not mediate a case that they arbitrated. And that makes sense, because an arbitrator is making decisions, is hearing things in really a more adversarial setting, to then shift into a different neutral and impartial role, of a facilitative role. I can understand, and I know Mia was one of the dissenting opinion on that, but that makes sense to me. But there is a committee note to the self-determination rule, because remember, mediation is all about self-determination, among other things, but there's a committee note to 10.310 that says, on occasion, a mediator may be requested by the parties to serve as a decision maker. So it's a different setting. Now the process has started out as a mediation, and at some point the parties realize, you know what, we're not going to agree. We want, Louise, you to arbitrate this. I mean, they use the word decision maker. I mean, to me, that means arbitrator, someone who is going to decide the case. And basically what the committee note says is, if the mediator decides to serve in such capacity, so you can do that. I'm not comfortable with it. And again, we don't have time today to get into the in-depth discussion about the potential problems and pitfalls of making that choice and stepping out of that role into that different decision-making role. But it says, if the mediator decides to serve in such capacity, compliance with this request results in a change in the dispute resolution process impacting self-determination, impartiality, confidentiality, and other ethical standards. Before providing decision-making services, therefore, the mediator shall ensure that all parties understand and consent to those changes. And the gist of the committee note is that, again, self-determination, the parties can really pretty well craft whatever dispute resolution forum they would like to. And this is one, I guess you could call it med-arb, where it starts out as a mediation and it segues into an arbitration. So, in any event, that's there. You can take a look at it when you've got the time to do that. 10.330 is the next one I want to touch on. Impartiality, a mediator shall maintain. Yes, Carmine. We're going to get the mic back to you here.
Back up to the last one.
Sure.
Okay. I'm fresh off of personal experience in that particular situation, and it's fraught with landmines. And be very, very careful because the disposition of the parties, and you may think, well, I can help them. I got a handle on this, because you've got the potential confidentiality issues, because remember what they say today and even what they might write down tomorrow when they're mad or they're upset, it becomes a different ball game, and you are in the frying pan, my friend. So it's something that you really want to look at very, very carefully and be very protective of yourself before you jump from that mediation to arbitration.
Agree,
role.
for the very reasons, and as you know, we could talk about that for the next 30 minutes, which we won't do that today.
I will say that the Florida Bar will never put you in that position, so you don't have to worry about that. We would call up another arbitrator.
So as to impartiality, 10.330, generally a mediator shall maintain impartiality throughout the process. It means freedom from favoritism or bias in word, action, or appearance. So even the appearance of partiality can be problematic. And includes a commitment to assist all parties as opposed to any one individual. And I think that's a really good way to describe it when you're describing the process in an opening statement, is that I'm required to be neutral and impartial. And basically what that means is I'm here to help both of you or all of you or however many of you are here reach an agreement, not one party over the other. And I do go one step further. This is just a pet peeve of mine. But I will say something like this. And if you think that anything I'm doing or saying is problematic, or you have any problem at all with what's happening in the mediation process, please let me know, or if applicable, let your lawyer know, and they'll let me know and we'll address it immediately, because I'd rather deal with it here and now today rather than 6 weeks or 6 months or a year or two later in some kind of a grievance context. And so that's just an extra step that I take in terms of trying to reinforce that idea of what my role is not, and make sure that I have hopefully an opportunity to address it if and when someone has a concern about what's happening in a mediation. The rule goes on to say a mediator shall withdraw from mediation if the mediator is no longer impartial. You know, sometimes you hear things, somebody makes a comment that you find so offensive that, you know, you just can't mediate for this person anymore. If that happens, you need to recuse yourself, withdraw right then and there. If that happens, it's not a common thing at all, but sometimes things happen and impartiality can fade away. Maybe it's the way the case is being argued or litigated or whatever it is, you know, or you begin to really see it one way rather than the other, and you know, can no longer be impartial. Just get out, end it right there. And that's the most solid ground you can possibly be on from an ethical perspective. Again, I think this goes without saying, but I'll say it briefly. Gifts and solicitation. A mediator shall neither give nor accept a gift, favor, loan, or other item of value in any mediation process, nor shall you solicit or otherwise attempt to procure future professional services during the mediation. Obvious no-nos. Conflicts of interest are discussed in 10.340. Generally, you're not supposed to, as a mediator, mediate any matter that presents a clear or undisclosed conflict of interest. Conflict of interest arises when any relationship between the mediator and the mediation participants or the subject matter of the dispute compromises or appears to compromise the mediator's impartiality. Family, relations, former law partners, former clients, not former law partners, former clients. Those are considered, as are family relations, to be not by the MEAC. Okay, it's an opinion where they say that we, the 9 mediators who were on the MEAC at the time, think it would be improper for a mediator to mediate a case involving a former client or certainly involving a family member. And that to me makes more sense than the former client, because that could depend. But again, we're not going to get into the weeds on that, but there is a MEAC opinion out there on that. Burden of disclosure. The burden of disclosure of any potential conflict rests on the mediator, of course. And we're going to talk about this from the Florida Bar Rules perspective as well, but I'll go ahead and say it now, and I'll probably say it again in the next section, that you do that as soon as you know it. You just make the disclosure and give the party. Believe me, you don't want to be the mediator in a case where if there's any chance that there's a conflict and someone sees you, being in a conflicted position, oh no, I can fix that, or I can cure that, or I can deal with that, or I can set it aside. It's not worth it, in my humble opinion. Again, you make your own professional determinations in that regard. The effect of disclosure. After appropriate disclosure, the mediator may serve if all parties agree. Now that's talking about a waivable disclosure. I mediate with so-and-so 5 or 6 times a month or 5 or 6 times a year. Just thought you might want to know that. No problem. They've waived it. You're comfortable with it. rock and roll. You're ready to go. The problem, as you all can well imagine, is if you don't make that disclosure, you mediate the case, something happens, somebody finds out, and now all of a sudden it looks like the appearance now is that the fix was in. You know, you knew this person, you know which side of the bread, you know which side of your bread is buttered on, and you did something, whether you did or not, you did something. They're going to feel that you did because you hid it from them and you didn't disclose it. So it's just not worth it. Make the disclosure, make it as soon as you know it, and if they disqualify you, then you're that much better off. Demeanor. This is definitely one you would think would go without saying. 10.350, a mediator shall be patient, dignified, and courteous during the mediation process. Read the Valsheen case. You'll get a good chuckle out of the way that rule was grossly violated. All right, confidentiality. 10.360, a mediator shall maintain confidentiality of all information revealed during mediation except where disclosure is required or permitted by law or is agreed to by all parties. When you make the opening statement, include the whole sentence. It's confidential except as required or permitted. I can't tell you how many times I hear people say there's a period after mediation's confidential. And that's all that's said about it. No, it's not. It's confidential with 6 exceptions that you could drive a Mack truck through. And not as the settlement discussions, but a lot of other things can happen where it isn't confidential. And you don't want to be the mediator that said it was, and now it's not, and it just doesn't look good, and it could be a potential problem on the grievance side for the mediator as well, for not making that disclosure, because you are required to make an opening statement that talks about that. But that's there's another rule that really isn't germane to our main focus here. Now, caucusing is the notion of meeting privately with the parties. And again, you heard Mia say you do not have ex-parte communications in an arbitration. You have them all the time in a mediation. Before the mediation starts, well, maybe not statutorily before the mediation starts, but before they've all come to your office at 9 o'clock Friday morning to begin the mediation, you maybe have had phone calls with the counsel or parties if they're unrepresented or whatever. At the mediation, you're going to be meeting with them together. You're going to be meeting with them separately. Ex-parte communications happen all the time. However, it's important to know that information obtained during the caucus may not be revealed by the mediator to any other mediation participant without the consent of the disclosing party. So that's the requirement there, that you keep that information. And that's the way I explain it. When we're in a caucus, I'm meeting with you and your lawyer, or just with you if there is no lawyer. Whatever we discuss stays between the two of us unless you authorize me, in terms of the process, unless you authorize me to share it with the other party. It's plain and simple. And before I'm finished with that caucus, I'm going to ask them one more time, now this is what I understand I'm going to be sharing with them. Is there anything I've missed? Is there anything else you want shared? Is there anything I've said that you don't want shared? Because I want to make sure I'm on as solid a footing as I can be to not come back and say, oops, you know that thing you told me you really didn't want repeated? It's kind of slipped out. That's not a good thing. So you want to take whatever precautions you can to maintain the confidentiality. Boy, the next one, we could spend a half a day talking about this, because we usually do at the CME classes. 10.370, advice, opinions, or information. Subsection A, providing information consistent with standards of impartiality and preserving self-determination. Again, these are overriding concepts. You'll see them throughout the standards. A mediator may provide information the mediator is qualified by training or experience to provide. All right, that's number A. B, independent legal advice. When a mediator believes a party does not understand or appreciate how an agreement may adversely affect legal rights or obligations, the mediator shall advise the party of the right to seek independent legal counsel. And it's always my caution to whomever I'm speaking to that it's really poor form to do that if they've already got a lawyer sitting next to them in the mediation, even though it may be tempting. And you may really believe that they have a lawyer who's there, but they really don't have a lawyer because he or she doesn't know what they're doing. And that's an awkward situation, and again, we can have conversations around that. But the point is, this rule is intended to deal with unrepresented parties who truly, when there's where there's a client and no lawyer. That's when that would be utilized. And finally, subsection C, personal or professional opinion. A mediator shall not offer a personal or professional opinion intended to coerce the parties, unduly influence the parties, decide the dispute, or direct a resolution of any issue. Consistent with standards of impartiality and preserving self-determination, however, a mediator may point out possible outcomes of the case and discuss the merits of a claim or defense. I mean, that sentence alone gives you, I think, a lot of leeway to do what you need to do to effectively and ethically mediate the case. But just have to understand and respect the fact that the parties may not agree with you, or the lawyers. They may still choose to do whatever they want to do, even though you've pointed out possible outcomes and you've done certain things that are within the rule, discussing strengths and weaknesses, et cetera, et cetera. That doesn't mean that you have to convince them. It means you get a good shot to try to convince them. And I once heard it described, and then we'll get to you. We've got a question or comment coming up here, that the role of the mediator, you all have heard the phrase, you can bring a horse to water, but you can't make him drink. Well, this is a speaker that I use for the domestic violence segment in my CME classes, who is not a mediator, by the way. And after attending a number of classes and training and talking with mediators, she says, it occurs to me that your role as a mediator is to basically bring the parties and or lawyers to the well and make them realize how thirsty they are. And that's a really good, simple, elegant, important distinction, because, that's it. It's the power of persuasion. And if you've persuaded them and they come along, great, you're probably going to have a settlement. If you've done your best and they're not going to come along, then there's not going to be an agreement. And that's okay. And that's got to be okay with the mediator. And I'm not saying you give up at the first sign of difficulty, but I am saying you don't try to make someone reach an agreement when they don't want to reach an agreement. That's my view of it. The committee note goes on in great detail, talking about, and by the way, I think this is problematic, but it says a mediator may raise issues and discuss strengths and weaknesses of positions underlying the dispute. I think raising an issue as a mediator, if a party or counsel hasn't raised it, could be very, very problematic. The committee note says you can do it. So far be it from me to say you can't. It says right there, a mediator may raise issues. But just think about it for a minute. Any issue that you may raise, if it in any way, shape, or form advantages or disadvantages a party, I think that's a prohibition then, because now you've stepped out of the neutral role. You're no longer acting in a neutral and impartial way. If you're helping one party or hurting another party, that's where I think the bright line is in terms of raising issues. And you all may think of circumstances where you can do that. Again, we're not going to drill down into that today. There's just not enough time. All right, so that's 10.370. There was a comment, a question? Yes?
As a mediator, I would think that if you raise an issue with the other side, there's going to be determination later on whether the other side told you not to say it, or the other side didn't know that you realized it. You're giving information out to me that's close to malpractice. You're telling the side number one, by the way, did you think about A, B, and C? And you're giving advice that the other side either told you not to do or didn't mention it. How are you going to get around that?
Well, first of all, you shouldn't be giving advice.
Didn't you just say that you're raising issues?
Raising issues. And this is why...
When you raise an issue, you're inviting a question back from the lawyer or the client. Well, why did you bring up that issue? Or why do you think so? Right. When you say, well, I can't tell you, then you're giving away the horses because they know there's something else coming down the pipe. You're
getting into how challenging it is to be an effective and ethical mediator. That's no small potatoes to be able to do that. But giving advice, once you've acted as a lawyer, as an advocate, a lawyer, advocate, however you want to define it, that is prohibited under 10.370. You're able to provide information that you're qualified by training and experience to provide. I've tried a number of cases in this field, and these are the outcomes that I've seen happen. This is, it's my 5-minute alarm here to tell me I've got 5 minutes left on this segment. All right.
If the other lawyer, if this issue comes up between us and we're talking, and the other lawyer later on senses or finds out that you raised this issue or discussed this issue, that lawyer's going to come back and sue you.
They could.
Well,
that's
the
why
advice that you're talking about is pretty dangerous territory.
As someone else said, that's why we get paid the big bucks.
I think I said that.
To mediate these cases. It might have been you. I think it was you.
But I've seen this come up, and I just shrug my shoulders and say, I can't go there.
Well, let me just say this. I hear this routinely in classes. The comment is this, that mediation is practiced in the real world a lot differently than the way it's taught in the 40-hour class. And you know what? I know it, you know it, we all know it. And everyone has to make their own best professional judgment and best professional decisions about what these rules mean, how they apply, whether I'm going to follow them or not. That's you're supposed to. I mean, I teach the class in a certain way that these are the rules, and with a lot of classes, it takes them 2 or 3 days to even begin to get, okay, wait a minute. This starts to make sense. I'm starting to get this now. I see this. This is really hard work. They think that mediation is going to be a great retirement gig. It's challenging work to do it the way it's supposed to be done. It truly is. And I wish we had more time to get on that, but it's a really good point. It is a very slippery slope. It's a very risky proposition. That I would agree with. All right, a couple more things that we'll touch on here briefly before we jump to the next segment. Responsibility to the process is 10.400. A mediator is responsible for safeguarding the process. Benefits of the process are best achieved if mediation is conducted informally in a balanced and timely fashion. A mediator is responsible for confirming that mediation is an appropriate dispute resolution process under the circumstances of each case. There's some ethical obligations there that at some point, the judge maybe ordered it, and you find out fairly quickly, into the process that this is really not working. It's really no longer appropriate. It might have been 15 minutes ago, but based on what I'm saying and hearing, it's time to call it, call an impasse. And so you deal with whatever it is that you have to deal with, and that would be very rare that it would happen that quickly. But the point is that is your responsibility to the process to make sure that it is appropriate at the beginning, the middle, and the end. I do want to talk very quickly about 10.420, the conduct of the mediation. 2 things there. There's the orientation session talked about in subsection A and adjournment or termination in subsection B, and that's going to be about all the time we have on this segment. Then we're going to get to the Florida bar rules. But the orientation session, you're required, you shall describe the process and the role of the mediator and shall inform the participants that mediation is consensual, mediator is an impartial facilitator without authority to impose a resolution or adjudicate, that communications are confidential except where required or permitted under Florida law. And your opening can be that brief. I mean, you talk a little bit more about the process, but you can literally do it in less than a minute if you need to. And the reason that you may need to is because maybe you've got some real sophisticated parties and they don't need to hear the history of mediation and a 15-minute recitation of my resume. What they want to know is what I'm required to tell them. And I even ask them, I say, you want the longer version? They say, no, thanks, we're good. And then I can check it off. That's what I'm required to say. That's what I've told you. Yes?
Are you going to get in an argument with the lawyers? You give an opening statement, or you tell the parties that are there your background. The lawyers always, at least in the cases I mediate, always know what goes on, and they always tell their clients. But I thought my responsibility is to the civilians that are sitting there. They may not understand what mediation is about, even if their lawyer told them 15 minutes ago.
Right.
You've got to elaborate your background and what's going on here, and that you can't force them into anything.
Absolutely.
And it may take a few minutes, but then they understand.
Well, it takes what it takes, and the rule requires that you make it, and that's my point. Even when someone says, hey, come on, waive it, you have to say respectfully, no, thank you. I can't. Now, adjournment or termination, and these are all prefaced by a mediator shall. Adjourn or terminate upon agreement of the parties. Adjourn or terminate any mediation which, if continued, would result in unreasonable emotional or monetary cost to the parties. Adjourn or terminate if the mediator believes, this is a very subjective standard. I'll bet you there are 18 different beliefs in this room as to whether or not and when a case is unsuitable for mediation, or if it's even unsuitable. But that's what it says, if the mediator believes. So that's the standard. Or any party is unable or unwilling to participate meaningfully in the process. So those are the things you have to look out for. Again, shall terminate a mediation entailing fraud, duress, the absence of bargaining ability, or unconscionability. And number 5, terminate any mediation if the physical safety of any person is endangered by the continuation of mediation. And fortunately, that's not a common occurrence. It does happen. Hopefully you can find a secure facility in which to mediate. Someone mentioned that some of the Florida bar sites are secure. I know there used to be one at the Tampa airport. I don't think they have the space there any longer, but if courthouses obviously are secure, so there are facilities where you can make those arrangements. And then finally, closure, the mediator shall cause the terms of any agreement reached to be memorialized appropriately and discuss with the parties and counsel the process for formalization and implementation. So the rules don't require that you write the agreement, but they do require that you see to it, if there is an agreement, that it gets done. And probably the best way to do it, and Mel Rubin, God rest his soul, he used to tell me time and time again that it was, he didn't say it this way, he didn't say it quite this diplomatically, that it was a very risky proposition for me to write mediation, for mediators, not just me, for mediators to write mediation agreements. Again, you have to make your own decision. You're not required to. I think most mediators that I know do it. I do most of my agreements. Some of them, if they're particularly complex, complicated, multi-party, then I will enlist counsel to get involved in that process, and they do. But again, the rule does require that you somehow see to it that it gets done. And that's about all the time we have on the standards. I think we got through most of the ones that I wanted to touch on. And so now we're going to shift gears to the Florida Bar Rules, 14-1.2. The program has jurisdiction to mediate the private rights of the parties, not discipline issues. And so, Chanel, I don't know how much elaboration, but I guess it's really like, for instance, the one we're going to do is an economic refund of a fee or whatever, as opposed to any discipline or malpractice or anything else that may have arisen that would not be subject to mediation.
That's correct.
Okay, and that's what that rule says. The program does not have jurisdiction, to resolve issues in a disciplinary file, which must be resolved within the disciplinary process. And by the way, FYI, there's a whole section 3 in the mediator standards on mediator discipline, modeled very closely after the Florida Bar disciplinary rules and standards. I don't think it's verbatim, but it's pretty close to it. All right, so the Florida Bar Rules for certified and court-appointed mediators applies unless otherwise stated or in conflict with the rules regulating the Florida Bar. Now, that's interesting because 10.650 of the mediator rules says that other ethical standards to which a mediator may be professionally bound are not abrogated by these rules. In the course of performing mediation services, however, these rules prevail over any conflicting ethical standards to which a mediator may otherwise be bound. So, you've got different professions all saying that our rules trump, unless otherwise agreed. But there is a Florida bar rule, I think Mia referenced it, the lawyer serving as third-party neutral, which there's a sentence in there somewhere that says when a lawyer is mediating, the lawyer is bound by the mediator standards. So it's interesting. I don't know how it would all flesh out if there were a conflict, and there seems to be some kind of conflicting language in the different rules, but the Florida Bar Rule dealing with lawyers serving as third-party neutral does specifically address it and does reference the fact that when you're acting in that role as mediator, that you are bound by the Florida standards for certified and court-appointed mediators. So there's that. That's 10.650. And let's see, tab 7.22. Okay, all right, we've talked about that. Now, there was also, I think, in the Florida Bar rules, a provision that a program mediator shall not report the misconduct of another member of the Florida Bar if the Florida rules for certified and court-appointed mediators provide or preclude that. So there's some deference shown there, but that's really all the language I could find on how these rules interact with each other. 14-5.1, it's a violation of the rules regulating the Florida Bar for a respondent to fail to attend an agreed-upon mediation without good cause. Likewise, it is a violation for a respondent to fail to fully comply with the terms of a written mediation agreement without good cause. So those are the standards there that apply. 14-7.1 talks about members of the standing committee and mediators have absolute immunity. I think Mia talked about this earlier, from civil liability for all acts in the course of their official duties. All records, documents, files, etc., pertaining to mediation will be made available only as provided in the Florida Rules for Certified and Court-Appointed Mediators and applicable law, and that would circle back to Chapter 44. Because that's the Confidentiality and Privilege Act as well. So you've got to read these things in conjunction with each other. Some of the Florida Bar policies, let's see, policy dictates that persons should personally attend mediation conferences. However, if special circumstances exist and the mediator agrees, parties may be allowed to attend by telephone or video. That's pretty standard. I mean, basically in circuit civil cases, it's by agreement of the parties or order of the court. So there are ways in which someone can get out of appearing. You can think of the advantages and disadvantages. Having people there, on the one hand, it can be financially problematic, perhaps, so that would be an advantage of being able to appear telephonically or via Skype, which is how we're going to do it here. But I have to tell you, by and large, as a general rule, if someone asks me what I think about it, I think it's always better to have everyone there. I mean, just as a general observation. I mean, there may be reasons not to do it, and we can figure out a workaround that can be done. But something gets lost in the communication process. Even if they're on Skype, even if they're on over the phone, it's not the same as being in the room and looking and listening and just sensing, what's going on with people. So there's a high, in my view, a very high value to that, but there are reasons why, it may not be possible. 14.7.1 talks about members of the standing committee and mediators have absolute immunity from civil liability for all acts in the course of their official duties. All records, documents, files, etc., pertaining to mediation will be made available only as provided in the Florida Rules for Certified and Court-Appointed Mediators. Okay, I think I just repeated that. All right. Florida Bar Policies. Okay, the next one. Mediation is held at the office of the mediator unless otherwise agreed by the parties and the mediator. And again, I'm very flexible with that. If as a general proposition, if counsel wants to meet in their office, someone wants to meet in another office, it's more convenient. You know, I try to make it as easy as possible for that. But here, probably the office of the mediator in a case like this would be the best, most neutral, and the best choice of location. Counsel shall be permitted at mediation conferences only if approved by the parties and agreed to by the mediator. That's a little bit different. It's really more of a default in the civil arena. The counsel are present. Chanel, can you speak to that? Or were you going to speak to that?
Yes, actually, we do have a proposed rule change for that right now, where will be hopefully changed to read similar to the arbitration rules, where counsel is permitted, and it wouldn't be on, you know, just with the consent of all parties. So
Okay.
that's just out of fairness.
Okay,
It should go up with the next rule package.
very good. The mediation conference will be scheduled within 45 days of the referral of the file unless extended by agreement of the parties and the mediator. Again, usually these things unless otherwise agreed is not an unusual caveat to many of these rules. The mediator will report to the program administrator the file reference number, whether the matter is settled with or without formal mediation. If formal mediation was held, the date of the mediation, the parties who attended and those who did not attend, whether the mediation resulted in a complete settlement, partial settlement, or impasse, or I guess a question I'd made to myself here, could it be continued? Is that a possible outcome as well, or?
I haven't seen any of them that were continued, but there's nothing that prohibits it. If it
Okay.
would be just postponed for a while, maybe until the parties could get back together or something of that nature.
Okay. When a disciplinary violation of a sort not proper for mediation is divulged, or if a party appears to be incompetent to participate in the mediation, a statement should be made that the matter is no longer proper for mediation without elaboration. Obviously not the kind of situation anyone wants to confront, but if something does happen, basically the way you address that is, something has come to my attention that makes the mediation no longer possible to continue. Thank you for being here, and I wish you all the best, and it goes wherever it goes. I mean, unless there's any other way of concluding it. But again, you certainly wouldn't divulge the specifics of what gave rise to that. That would not be appropriate. Ethical considerations. Conflict checks for the mediator. The scope would include the entire firm, I presume, not just the lawyer who may be involved in the case, but any other relationships that the mediator may have had with any other lawyers in the firm, whether co-counsel or personal or professional or whatever they may be. Conduct the conflict check before the appointment is accepted. Again, you want to give the parties the right to say, or for you to say, this is not an appropriate case for me to serve as mediator in. And if you do that at the mediation, it can be problematic in terms of people are there, they've taken the time, expense, and inconvenience of appearing, and now they find out there's this conflict that could have been divulged 6 weeks ago. Certain conflicts cannot be waived even with disclosure. The MEAC opinions talk about that. Are there other conflicts in within the confines of the grievance mediation program that cannot be waived? Okay, I can't either. In terms of the disclosures, scope of disclosures, timing, I would say do it as soon as possible and as broadly as possible. I mean, just as a general rule, the more the better, and the more solid ground you as the neutral will be standing on by getting everything out there that could possibly be a potential problem. Again, before accepting the appointment is the time that it should be done, not at the mediation, unless new information is learned and the conflict has just arisen. You just now became aware of something that you weren't aware of, 30 seconds ago. So you make the disclosure then and there. I had that happen where someone told me in a mediation, it wasn't a Florida bar case, but it was a civil case. She says, I think we're cousins. And, frankly, there was a really good likelihood because my grandfather who came here from Italy had 13 brothers and sisters, and we have literally hundreds of cousins in Tampa. And it was someone, it was a different name and one that I didn't recognize, but it was, something. But nobody objected to it. I didn't know this person. She'd heard my name and I hadn't heard hers, but in any event, it turned out not to be a problem. But when something comes up, you deal with it. You just handle it on the fly. Continuing duty to disclose. So it's not like, okay, now the mediation has begun, so I've met my obligation. You have to, it doesn't end until the process is over with. Ex-parte communications, we've talked about the caucusing, and obviously, and that's a very important part of the mediation process, the caucusing. We haven't talked a whole lot about that, but that's really where a lot of things happen that just simply are not going to happen when everyone's sitting in the same room. For whatever reason, people are just more comfortable talking one-on-one. And again, you have to be very clear in terms of, what you're authorized to disclose. And my fail-safe, and so far it's worked without exception, and hopefully it always will, is at the end, I just say, okay, first of all, I'm assuming everything's confidential, number one. And there's another way of doing that. MEAC has opined that you can basically say, if you all agree, I'm going to assume that everything is confidential unless you tell me otherwise. The problem that I have with that is that somebody, you can agree to that and then somebody doesn't think about something and it just seems like it can lead to problems. I would much rather have it where nothing leaves this room unless you authorize it. And here are my notes. This is what I understand I'm talking about. 1, 2, 3, 4, 5. Look them in the eye. Yes, yes, got it, and I go. That to me is the most airtight way to make sure I'm not coming back and saying, oops, I know you didn't exactly say that, and I thought it was not confidential, and you're looking at me with platter eyes now like, are you kidding me? You want to avoid that at all costs, if at all possible. All right, let's see. So, sometimes there are cases where, and really I'm thinking more in the family setting, that it's more common, at least in my experience, where the parties, they don't want to see each other. They don't want to hear from each other. He doesn't want to smell her perfume, whatever it is, they just want to be in separate rooms from start to finish. So the entire mediation can be conducted in caucuses, and that's fine. There's nothing improper about it. You hate for it to happen that way, but basically the way I explain it is any party at any time can request a caucus. And sometimes someone says, okay, I want to do that right now. And so it begins, and there we are. And so that's, again, part of the self-determination aspect of it. Think about it for a minute. I don't know a whole lot about these people, the case, the dynamics, anything at all. I think, well, no, I want to make my opening statement and I want to keep us together as long as I can. And all of a sudden, the dynamics turn into fireworks, because I thought I had to do it in a certain way, because that's the way we learned how to do it, or that's how you start out a mediation. We're going to have a group hug. Well, maybe not necessarily a group hug, but a group general session. Sometimes that's not the best thing at all to do. And again, I think you just need to be attentive to what you're dealing with, what are the personalities involved, and what's going to get the process off on the right foot. That's really what you're there to do. Not throw a hand grenade into the middle of something because you didn't realize it was coming, or that you didn't recognize that somebody was about to boil over. So I think that's for the parties to decide, and your common sense and just paying attention. All right. So, maintaining neutrality. It's one of the more challenging things to remain neutral and impartial. Everyone who is doing, well, no, I guess not everyone is a lawyer. There can be non-lawyer mediators in this program, but most are lawyers. Okay, and so lawyers have the training to be advocates and to see things in a certain way and perhaps express things in a certain way, it's fine to disagree with someone or with something that you hear, but the neutrality part of it means you're not there to help either party, even though you may feel like somebody needs it or deserves it. It's not your role in this process. No assistance to one side on the claim or defense is the same thing, basically. Well, that's the impartiality side. I'm here to help both, not one or the other. And finally, we've got a few minutes left to talk about some best practices. Pre-mediation conference. I think it's a great idea. I like to know a little bit and maybe a lot about what it is that the parties are bringing to mediate, what are the issues, what are the personalities involved, a little bit about the history. I mean, frankly, a 15 or 20-minute phone call to me is a lot more valuable than a written mediation summary, because written summaries are just sanitized. They need to be, and it's fine that they are, and they should be, perhaps. But even if I get a written summary, I'm going to make a phone call, talk to each party before the meeting, or counsel, if they're counsel involved, because you always learn more than what anyone is willing to put down in writing and in a summary that they're going to send you. And it's usually pretty valuable stuff. Documents to review, contracts, whatever it might be, very helpful. Mediation summaries can be helpful. Documents for the underlying dispute, fee agreement, invoices, all of that stuff, just to get a feel, because that way, instead of taking 15 or 20 minutes at the beginning of the mediation, kind of getting an idea of who's on first and what's going on, if you walk in with that, you can get to it a little bit more quickly and really get to the meat of the matter in terms of trying to reach a resolution in whatever it's going to be, a 2 or 3 hour time frame. Are these set for a particular time? Is there a general
No, there's no time
frame?
frame.
No time frame. Okay. So they take as long as they take.
Right, the length of the time?
Yeah.
No.
Okay. And by the way, the mediation rules provide, and again, this is a general provision, that it's the mediator's obligation to schedule a mediation for a sufficient amount of time for the parties to freely exercise their right of self-determination. Now, I don't know what that means exactly, but it probably doesn't mean, 15 minutes or a half an hour or an hour. 2 hours, probably not. I mean, just my general sense, 3 hours at a bare minimum. And the way mediation started, at least in the Sixth Circuit, where I practice, in the 13th, the orders would come out and they would set mediations from 9 to 12 or from 1 to 4. And so people just got in their heads, 3 hours, 3 hours, 3 hours. And, maybe for a lot of cases that's sufficient. I don't know, it depends. But you need to do some due diligence. What's involved? How long do you all think this is going to take? Is a half day going to be sufficient? And for me, a half day is either, 9 to 1 or 1:30, and then maybe 1:30 until whenever. You can go from the afternoon segment until whenever people want to stop. Telephone conferences, I think, again, is definitely a worthwhile few minutes of your time. The conference itself, introduction, opening statement, joint session, private caucus, reaching agreement or impasse, those are kind of the things that happen. And we're going to do a role play here in just a couple of minutes that will kind of demonstrate those things insofar as we can in a 30-minute role play. I will say this, and this will be, we might have another couple of minutes for questions, that I have found it to be particularly helpful to, whenever someone mediates in my office, and even if it's in someone else's office, I make every effort to meet separately for a few minutes, 5 or 10 minutes max, with each party. And if there are multiple parties, then with however many, 3 or 4 parties, however many there are. But to talk a little bit about the process, a little bit about myself, a little bit about what's going to happen, and to give them a chance to just kind of take a deep breath and really for me to build rapport. Because picture for a minute an opening statement, which we're going to see because we don't have time to do it here with 2 separate openings. That's my 5-minute marker here. All right. Where everyone's sitting in the same room, and in this case, it hopefully won't be super adversarial, but they can be. And when they are, and everybody's in the same room, and they're staring at each other, and maybe there's even more body language than that, and arms are crossed, and you can just cut the air with a knife, and you're saying, good afternoon, welcome to mediation. My name's Charles Castagna. Let me tell you a little bit about the process. And I don't think people are really hearing you. I don't think people are really paying that much attention. They're thinking about whatever the next, the last rotten thing that SOB did to them before today, and the next thing that they're going to do to, whatever it is. That versus a separate opening, which takes about 5 or 10 minutes max, where you meet with one party with their lawyer and then the other party, and you talk, you make some small talk, you share a little bit about yourself, you sort of ease into the process, what's going to happen and whatnot. Do you have any questions? It just puts people at ease. It enables me to build a rapport that I frankly don't feel I can build in a more adversarial type of. And then after I do that with each party, and I've basically said the same thing to both of them, we get together. You're not waiving the general session. There's a general session where the lawyers, or in this case, the 2 parties, will have an opportunity to address each other across the table and say what they need to say and feel like they've had their day in court. But at least I want to get my piece out before the games begin. And they begin. I mean, it's as simple as once I had someone walk into a room, another party was already in there, they walked in and go to shake hands with them, and the person sat there like this. And they might as well have flipped them a bird, because that's how it was communicated, as far, it wouldn't even shake. And for the next 3 hours, all I heard about how is they wouldn't even shake my hand. How do you think we're going to get anywhere today, and all that kind of stuff. And you can't predict that. You don't know what's going to happen. And even starting separately and then bringing them together isn't going to prohibit that. But at least you've had a chance as the mediator to talk about the things that you need to talk about, to try to get the parties on board with the process and what you're going to do. And it gives you at least a fighting chance to get somewhere, because maybe they can set that aside and still realize that there's a good reason for us to be here, even though that person was acting like a jerk. And they were. I mean, that was a really unfortunate thing, to put it diplomatically, that they chose to do. And they did choose to do it. And there you are. So I think it's about time. We got time for maybe a question or two, and then we'll segue to the role plays. Whitney.
Really great presentation, Charles. Just one question I had from looking over Rule 14 and Chapter 14 is the Florida Bar Grievance Mediation Procedure open for counsel or a client to request the procedure independent of and having nothing whatsoever to do with a referral or a bar grievance?
I'm going to punt that
to the whole
Chanel.
crowd, yeah.
Good question.
Yes, it is. So a lot of times we get calls on our ACAP hotline where, the client will call and say, give us a scenario. a lot of times we have a little bit of education to do, where if the representation is still ongoing, the attorney hasn't withdrawn or hasn't been terminated at this point in time, we kind of say, well, it's really not a good time right now to do a mediation about fees, because you still have the potential for more fees to be incurred. So, but if it is an appropriate time, then we will go ahead and say, with your permission, we'll go ahead and contact the other side, or we'll send them out an invitation to do that. So it's completely separate and apart. It can just start out as, hey, look, I just need some help with a fee issue.
Are there any model forms for the bar has for that at all?
We do have a consent form for our program, yes, because because our program is a voluntary program, we need the consent of both sides. So we go ahead and set that up. Before we ever contact one of you as, to be a mediator for our program, we have already obtained the consents of both sides.
Excellent, thank you.
Anyone else?
Anything else? Yes, in the back?
Yeah.
Thank you for covering a great deal of information. In terms of the Vatakis-Falcine case, you're right, it's incredibly important opinion, because it does stand for the proposition that mediator misconduct can stand as a basis for overturning, reforming a mediated agreement. When it was remanded, the judge did not find sufficient basis of mediator misconduct to overturn the agreement. It's very likely that it only applies to court-ordered cases with a certified mediator. We don't have a lot of additional information as to other cases that have come down. It was before the enactment of the Mediation Confidentiality and Privilege Act, so it now would fit within one of the delineated exceptions that you identified in Chapter 44.
Right.
So it is really important. In terms of the Gulliver case, that's really interesting because it had a very broad confidentiality provision, which is why the plaintiff was not entitled to enforce the mediated agreement, because what he agreed to was not even disclosing the existence of the settlement. And in that, he also agreed that his portion of the payment of the settlement would be disgorged. So the lawyer got paid, but the plaintiff did not get his portion.
More than I knew about that one. Thank you. Thank you.
Anyone else?
Anything else? All right, thank you. You've been a great audience for this piece of it. We'll do about a 25-minute role play and leave a few minutes for some commentary on that, and that will be our afternoon. So I guess if the role players will make their way up here.
One thing I do want to kind of just briefly touch on while the gentlemen are making their way to the stage is that sometimes there is a possibility that as a mediator for the Florida Bars program, you might be asked to handle something via Skype or by telephone mediation. We do get a lot of complaints from inmates against their criminal defense attorneys, and they are involuntarily detained from coming to your office or a neutral location. So we try to do the best we can to accommodate those situations as well. We talk to their I can't remember the name of it, the officer that is in charge of over them, and they can usually make a room available and a telephone available. We have some conferencing abilities so that we can provide a call-in number for them for that purpose. We'd probably have to arrange that well ahead of time with the bar branch office so that we would be able to track that call.
Oh, just for clarity purposes, I'm still going to play the role of the attorney. Sandy, who was the arbitrator before, is now going to play the role of the client, so we'll call him Andy Andrews for this.
Andy, all right. So Mr. Andrews and Mr. Mitchell. Gentlemen, good afternoon. Welcome to mediation. My name is Charles Castagna. It's an honor and a privilege to be here to try to help you all resolve your differences and come up with an agreement if you choose to do so. I've been mediating since 1988. I've handled thousands of matters as a mediator. Most of them get resolved. Sometimes they don't. and that's what other processes are for. But hopefully today will be one of the ones that we are able to get resolved. Some things that you need to know about the process and my role in it. It is an informal process, non-adversarial, consensual, and that you all are here by agreement. And it is confidential except as required or permitted under Florida law. There are two types of confidentiality. The general session, when we meet together, is confidential, as I've just explained. If and when we meet privately, and I don't know that we'll do that today, we may or may not have time to, but if we do, the mediation term for meeting privately with each of the parties is caucusing, and whatever we discuss in that setting will be confidential between me and whomever I'm meeting with, unless you authorize me to share whatever information we discuss with the other party. Today is all about negotiation, trying to come up with an agreement. It involves give and take from both of you. Hopefully you're willing to do that to try to find some common ground. But again, you get to decide. I'm not here as a judge. I am here in a neutral and impartial role, not to take either one of your sides, but to hopefully help both of you talk this thing through and come up with something that makes sense. The reason most people settle disputes in mediation is because you control things here today that you don't control in a setting where someone else is making a decision for you. The time, the risk, the uncertainty, and the expense, all of those variables are 100% within your control here today. I understand Mr. Andrews is Skyping in. It looks like we've got a good connection. I can hear you loud and clear here. So we've got a great opportunity, and let's get started.
Okay.
Whatever opening comments.
Would you like me to go first? I'm happy
Well,
to go first.
I guess the petitioner would be the party that would start.
I waive my opening.
Well, I'd like to say something. You asked me to represent you over a year ago. I did everything I could. You know, you say I wasn't responsive to you, but...
Could you direct your comments to me? That would be...
Okay, I can do that. Well, the bottom line is I represented Mr. Andrews for over a year in his divorce proceedings. It was a very contentious divorce. Ultimately, and I'll make this very quick, he had a $15,000 retainer. It was non-refundable, earned upon receipt. The letter of the law says that that is mine if I do work for him. I did work for him. I did a lot of work for him over the course of a year. I had a fall. I had a lot of injuries right when mediation was about to occur. And I was frankly, I was a little bit confused. I called the courthouse. I didn't call him. That's my mistake. Okay, and I'm sorry for that. I know you asked me to speak to you, but I just want to say I'm sorry that I missed your mediation, sir. But the bottom line is we had an agreement. And I think it's enforceable, and I'm here seeking actually another $1,100 because I did more work than beyond the $15,000 retainer. And that's why I'm here. I'm here in good faith, but I don't want to be taken advantage of either.
I don't think he contacted me sufficiently or tried to contact me. If you look at 11 months gap, it's not, the case wasn't that complicated. He should have been able to tell me why or bring in another lawyer to continue the case till it's finished. And I think if you look at some of the hours that he has, I think they were just way overstated, and some of the costs incurred wasn't proper. He could have had his paralegal in the office call me for that matter.
I don't have anything else to say.
So is there anything else you'd like to share with the opening?
I just think that he owes me some money back. I think we should negotiate that, and we should try and reach a fair and reasonable resolution.
What sort of money back are you talking about?
I think it was $1,100, $1,200, something like that neighborhood. I don't have my information with him, but he's got that. We try to inform him of it.
Because one of the things we need to sort out here, you're looking to basically keep, you've got the retainer.
I was paid the retainer, I earned the retainer. I'm looking for the extra $1,100 that he still owes me because my time exceeded the retainer. I don't know what he's looking for. He brought this claim. I guess he wants some of his money back.
Well, and that's really part of what I want to find out here today is what are you all looking for to try to get this thing resolved? What do you want to see happen here today?
I don't think I should pay him anything. I think he owes me something back because he hasn't kept proper accounting records the court requires him or the bar requires him to do. And I think that's where the problem's really occurring. His failed record keeping, his failed communications. I felt like I was sitting out there in the cold.
Can you address some of the concerns that you've heard raised?
Yeah, he says, I didn't keep good records. Here's my timekeeper report. It shows that I put in 46 hours. He thinks I wasn't responsive, but, I can't really do anything. I can't disprove that. I mean, other than to tell you that, no, of course I was responsive. Did I get back right away? Maybe not. There were times where I didn't get back to him right away. And I could see how, that might upset him a little bit. But again, the bottom line is I did a whole lot of work for him, and
It wasn't a
work
little
for
bit,
free.
it was a lot. I was distressed a lot. He just didn't get back to me. He brings time records today that I don't really think I've seen before, and they're insufficient records. He's got certain billing in there that, he should have given me ahead of time or set up a conference, so I wouldn't be a PO'd client. I'd be sitting down with him and talking to him about what happened and why it's delayed. After his accident, he could have called when he got better, and we should have sat down and discussed where we're going and when we're going.
All right. Can we talk about specifically as far as the, let me ask you this. Do you feel like you received any value at all from what was done?
Oh, sure. He earned a significant part of his fee. I'm not going to deny that. I won't comment on the quality of the representation, but he earned some of his fee, a significant part of it.
And the retainer was $15,000. He's seeking an additional $1,100. What do you feel? What to you is a significant part as far as what he has earned?
He probably earned 11 to maybe 14,000, if that. Now you take a look at cases. It doesn't take that long to do this type of a case. 11 months is a long time. I'm surprised under the Supreme Court rules the court didn't issue an order saying, "Why is it taking so long?"
Now, have you offered up to this point any kind of a?
No.
Are you prepared to do that? Do you feel?
I think it's it's in his ballpark to see what he wants to propose for settlement, a complete settlement, all matters, cost, time, releases.
But you're thinking something in the $11,000 to $14,000 range is a reasonable fee? Did I hear you right? I don't want to put words in your mouth.
No, I think he's gotten a lot of money. I think it wasn't a complicated case. He said he may be entitled to some minor extra funds in there, and I think I've got a right for some money back under the costs and other things that he didn't use yet. So I'm open to see what he wants to suggest and what you want to suggest as a mediator.
Well, I can't really suggest as far as what you all ought to do here today, but certainly, do you, I mean, you've said that you want to keep the entire retainer plus an additional sum. Is that something that you...
Well, look, we arbitrated this recently with the Florida Bar's arbitration program. We're waiting for the decision still. It hasn't come out. We both looked at each other and said that arbitrator was pretty tough on both of us. So, maybe we should mediate this. I think there's some room that I'm willing to negotiate. Sounds like he's here in good faith, willing to negotiate too. Maybe, I don't know, it's up to you, but do you think now maybe might be a good time to caucus? And I think that's the word you used. And
mediation term.
And start negotiating, or is now not the right time? I don't know.
Well, we can do that. We're going to have to use the cone of silence if we do that, because I don't think we're set up to actually caucus. So if you can put these earplugs in your ear.
Turn off my hearing aid.
And turn off your hearing aid and
put them on mute.
Not hear the conversation that takes place. So we'll go into a caucus session. Whatever we discuss in this setting will be confidential between the two of us. I won't repeat anything to the other party without your permission and authority to do so. But give me an idea of what you think you might be willing to do, what you think is reasonable here today.
I mean, look, the buck stops with me. I know that I had some secretarial turnover during that time period. Maybe that caused a few delays. I can understand his position. I'll tell you, I like what I heard before, that he seems to think I'm now in the 5 figures, so that's a good thing. He's not asking for the whole $15,000 back. If I were being more fair, I probably could give up my $1,100 extra claim and maybe sweeten it a little bit if it would make him go away at this point. I want to be done with Mr. Andrews.
But you think at this point you'd be willing to give up the 1,100 extra claim and just keep the, what was it, 15,000 retainer?
Yeah, I mean, I'd be giving up the 1,100. The 15,000 is going to be a little bit tough to come out of pocket on. As you know, I sustained some major injuries, and I would need time to pay anything back anyway. But it would be tough for me to come out of pocket now and write a check. So let's start with maybe, as a sign of good faith, I'll knock off my $1,100 claim and see what he says. I have an idea. I have a bottom line idea, but I'm going to be honest with you. I'm a little hesitant to tell it to you because I know you said everything's confidential, but I'm afraid you're going to go back to him and he's going to say, well, what do you think he'll take? And I don't know how you're going to respond to it if you know my bottom line.
Well, that's not going to happen, but I don't want to know your bottom line.
Okay.
And I would encourage
Okay.
you not to share it with me because
Okay.
if you do, I'm going to ask you to change it later anyway.
Okay. You probably wouldn't believe me anyway, right?
Keep that thought. Not necessarily. But I am authorized to share with him that you'd be willing to drop the additional claim of 1,100 and just retain the retainer that you've been paid already.
Unless you think it would be offensive to him. I mean, I can come back I can now maybe offer a little bit over time back, but we're not talking a lot.
Well, it's not for me to say. It's really your offer and it's your case, and I'll do what I can to see if y'all can find some common ground with it.
Okay.
So whatever offer you want to convey, that's what I'll convey.
Let's just stick with the 1,100 now.
All right.
Okay.
We'll see what happens.
Let me know.
All right.
I'll be
I'll
doodling.
be back. So I've had a chance to chat with your counsel and a little bit about what he wants to have happen here today. This meeting, by the way, is, as I said in my opening statement, the mediation term is caucusing. I'm meeting privately with you. He's in another room. Whatever we discuss stays between us. First of all, let me ask you this. Is there anything that you didn't say in the general session when we were all together that you'd like to share with me that you think would be helpful for me to know at this point?
No.
Okay. Well, in order to try to move the matter along, your former counsel has agreed that he's willing to waive the additional fee, which he feels he's entitled to, at least according to his timesheets. I think he said there was 46 hours, I believe is what he's reflecting, was billed, and that it came out to be an additional $1,100 in addition to the $15,000 that you'd already paid. He says he's willing to waive the claim for the additional $1,100 at this point. But as we sit here at this moment, he does feel he's entitled to the the remainder of the retainer of the $15,000.
Haven't we paid him the $15,000 total retainer?
You have, and he wants to keep it, and I presume you wanted some of it back.
Yeah, that's a fair assumption. I would tell him to waive the $1,100 or whatever it is. I want my costs back. I think it was $300, $400, $500, something like that. And out of the money I've paid him, he should refund me at least $3,750.
So the costs back in those were, do I remember, $500?
Something in that neighborhood.
From the summary information I think I received, and then plus a refund of, what was it, about
$3,750.
$3,750.
And he waives the anything else, the $1,100 extra that he wants to charge, and executes a complete release of all claims from both of us after this payment. And the payment should be within 10 days. And he probably has to execute a stipulation that he's withdrawing from the case.
All right. Let me, is there anything else that you would like me to know, or does that pretty well get to where you feel this thing ought to?
I want my papers back. I don't want to have to go back out and recopy everything with all the original documents that I gave him.
All right, so what I understand you're willing to do is you're proposing that you would receive the cost refund of $500 plus $3,750 from the $15,000 retainer. You'd want to have him sign a stipulation to withdraw, return all of your legal papers, and basically a full and complete release and payment within 10 days.
And I think you should specify that that he doesn't have any right to this $1,100 claim. Since it's claimed in there, we want to specifically address it. And
yeah, this would be a full and complete release and a waiver of any other claims.
Yeah, total claims, yeah. That could have been or should have been brought under this matter.
All right.
You know, I could ask for more back, but I'm just trying to be reasonable in the offer that I gave him.
Well, let me run this up the flagpole. I'll chat with him. What I summarize, is that
Yes.
basically where you're coming from? Anything in there that you don't want me to talk about?
No.
All right, that's what I'll talk with him about. I'll be back shortly. Thank you.
What do you say?
All right, what he is willing to do, is he'd like the $500 cash deposit back. He'd like a refund of $3,750 out of the $15,000. He feels that's a fair adjustment to the fee in terms of what he feels you earned. He wants that paid within 10 days. This would be a full and complete settlement, total waiver of any other claims that you may have, each, full and complete release, that you would stipulate to withdraw from the case and return any legal papers of his that you've got.
All right, so maybe I can address a few of those. He can have his whole file, of course. Check. All right. He already fired me, so I'm out. If he wants a further stipulation, I don't know. The court will do what they want with it. That's fine. Check. Yeah, I want a release from him. He gives me a release, of course. I do have some ethical concerns about the $500 cost deposit being paid back in full, because I did have to pay $295 from it for some filing fees. $205 is remaining. He can absolutely have that back. He's entitled to it. But the $295, I can't give that back to him. It was a cost, and I don't want to be viewed as having possibly paid for my former client's costs. So that's a non-starter for me. On the money, okay, here's where I am on that. I was taking a look at my timekeeping report when you were meeting with him, and I tried to be a little bit fair here. One of his complaints during arbitration was that I billed for $700 in travel time. I think I'm entitled to my travel time. Okay, it was a reasonable cost here, but $700, I think I'm willing to give that back. I also looked. I kind of feel bad about this now, honestly. Don't tell him I said that, please. But I did bill for preparing for mediation, and I wasn't at mediation. So there's about another $1,000. So I'll pay him back $1,700, okay? But I need a little bit of time to do it. I think I can make 2 payments over the course of 2 months. I have a lot of medical bills right now. A lot. A whole lot of medical bills. I'm very unhealthy. No one ever laughs at my jokes.
I can see why.
And I'm wondering, and we can talk about this afterwards, if my antenna should be moving as far as the amount billed that you didn't. We'll talk about that afterwards.
Yeah.
The prep time. All right, so he can have his file. You're willing to do a stipulation even though you've been fired, mutual releases, and the ethical concerns you've raised regarding the $500 deposit is that you've spent some of that in costs. You'd refund the balance of that. And as to the fees, you're willing to refund $1,700 relating to travel costs and mediation prep time, as well as 2 payments. But you'd need 2 payments over 2 months to do that.
That's right.
And is that pretty well?
I think that summarizes it. Of course, the $1,100 is still waived.
All right.
What was it?
Got to keep an eye on this. We've only got 5 minutes. I'm out of roll here, obviously, to discuss. Should we pull it now and talk about it? Because I don't want to run over time. Okay. All right. So
He takes it.
what's the, yeah, let me at least convey the offer.
No, it's fine. It's fine.
Is it snowing outside yet?
All right. So, thoughts? Anybody? Role players? Audience?
Well, I don't know, what did he say about that 1,100? Going to wipe that out.
The 1,100 is waived, and he's going to refund 1,700 related to travel costs and mediation prep time. He'd need 2 months to pay it, 2 payments over 2 months. And then the cost, he can refund 205 of those.
Says I fired him.
He would agree that he's been fired. I think.
Well, there's the quality of his representation. You see, I could fire him, but he needs a court order relieving him from the case. He's still on it.
Let me just clarify. Are you fine with the stipulation of?
I'm fine. We got a deal. Let's get out of the role play now. So maybe I could raise 2 things with you, because I did try to inject them a little bit, and I'm curious your thoughts on it. The first is what I raised about talking about bottom lines. Okay. Now, people have told me what, they'll say, I'm not going to go below this when I've been mediating cases, and I never believe them anyway. But, I do find that you cut me off. You didn't even, you said, I don't want to know it, right? But sometimes people do say things and, you don't even know that they're about to say it.
Right.
And I find that it does create a bit of a quandary when the other side says, do you think that they might go for this? And I think your response is where my second issue is, you say, I'm not going to tell you anyway what I think they might go for. But is that correct, that you just, as a matter of course, will not say, hey, this is what I think they might go for, this is what I think a fair offer would be, or anything like that?
I wouldn't say this is what a fair offer is. I might say that, depending on what I've heard, this is a range in which I think the case might settle.
Okay.
If you've given me enough, to maybe say that without making it a firm offer, but I'd want some clearance from you to do that.
And really the second issue was where I said, do you think that he might be insulted if I offer this? What do you think the reaction will be? And it didn't sound like you're comfortable saying if you think the other side might be insulted by an offer, because what you think I'm asking, is it a good offer and that takes it too far?
That's kind of my sense, is that you're kind of asking me whether I think it's a good idea or not. If I think he's going to, if I think he thinks it's a good idea, then I think it's a good offer or not. You might be reading into what I think.
See, I find that sometimes if we're making very, very small moves, in a huge, we're just gulf apart, and then we're making extraordinarily small moves, and then one side makes a larger move, and the next one goes, okay, great, I'm going to make this tiny little baby step again.
Right.
I have said in the past, that might trigger a reaction. Consider whether that might trigger a reaction that is going to be more counterproductive. If you're willing to go higher, maybe now might be a time to make a slightly bigger move, but of course that's up to you.
Or how do you think they will react to that? Might be another way for the mediator
Right.
to say, this may not be such a good idea.
Yeah.
Yeah.
This must be difficult for you, because you probably hear things through these questions, I'm imagining, where you go, well, you really shouldn't say something like that.
Well,
but that's part of the learning
No,
process.
but if you hear something, I think it's the mediator's on solid ground. If you hear an offer that you think is going to really be problematic, to say something like, what do you think the reaction is going to be?
Right.
And you bring out that discussion. Yes.
There's, I know when I start the individual sessions, I always say to the people, do you ever go fishing? Do you do that? Yes. Whether they say yes or no, I say you can't catch the fish if you don't put any bait on the hook. That's kind of, whatever. But it really gets them to think a little bit, because when they make a stupid low offer, what I think is stupid, but I'm going to tell them that. What are you going to accomplish with putting in 4 more steps before you get to a realistic offer that somebody's going to consider? You have a lot of insurance companies, they'll offer $500, they know the case is worth $50,000, and they want you to go all the way through, and it's dumb. And you got to let them know it's dumb. Because then you go back to the other side and you say $500. They're going to say, what, are you kidding? And I always tell the other side, take the bullet holes out of my back. You can't expect to make a stupid offer. And I think it's on your obligation to tell them it's not the best offer. And you put some bait in the water and try and get them to at least acknowledge. And you can go to the other client and say, well, they made a reasonable first offer. Let's skip a couple of steps and make something better. But I don't ask for their final offer. But you got to get them in the mood to realize the case is more. It also helps, depending on what kind of adjuster you have there. If they have a lot of authority without going to the telephone, which they're not supposed to do. But in a civil case, you just have to get them to come a little bit further, a little bit closer, a little bit further. And there's one other thing that you left out on the, if you have a joint session, and I learned this from somebody else, I always tell them to keep their mouths basically quiet in the joint session, because anything one side learns in the joint session by somebody blurting out something, if the other side can pick it up, has their ears open, and they can pick up and prove it independently of the mediation, it's fair game.
Right.
Did you get that? You're in the joint session, side A, side B. Side A blurts out, not his lawyer, lawyers know better than that. He blurts out something that side B picks up on. I don't care how obscure, obtuse, but from that statement of this guy in the joint session, he goes out and independently of the mediation can go out and get some witnesses and some proof, and then he can prove that up, that point to help his case.
Or for example, they say, to Sandy's point, yeah, I have a whole bunch of emails that'll prove X, Y, and Z, and you just know that you haven't requested that through discovery. Guess what's coming the next day if you don't settle.
You got to be careful. It's very good. You got to be careful. Make sure your client knows to keep their mouth shut. You tell them, as a mediator, you can say, you're going to get a separate session alone, and we can talk about that, and everything's going to be confidential. But in joint sessions, and this is in your introduction, don't say anything. Just sit there and listen. And the last thing I'll say, one last thing.
We are getting the wrap-up session in the signal now, so.
Want to open it up to the audience if they have any
questions? One last thing I think is important. We had an insurance adjuster, and she was staring at the other side's client directly. Very overbearing person. And I just said to her, no, you talk to me. You don't talk to his client. He's got a lawyer there. Because it's a form of intimidation. Any good adjuster can intimidate your client. And also, that client is not going to pay attention to what she's trying to tell her. So you just make sure that she talks to you, and either client listens to what the other side is saying, but that's what's going to make your case settle. Thank you.
Thank you all so much for this training.
Can I just ask one thing, and I'm
Yes.
going to ask you, what is the biggest difference between a grievance mediation and a general mediation? Either procedurally or just a general expectation, what is the difference?
Somebody's going to lose their license.
Interesting question.
Bottom line.
I think for our program, obviously, it is the fact, and you all are the experts here. You're the mediators. But I would think that the imbalance of power, probably, in the fact that you've got usually a client and going against their former attorney. So I think that probably is one of the chief differences that you would probably see right away in that. The other thing is maybe some time frames about just setting up the mediation hearing. There are some time frames in our rules about that. But
there's another imbalance here, is that the lawyer knows that if this doesn't settle, it's heading to the grievance committee.
it could possibly.
Right.
Scary as hell.
So there's a little bit of an additional incentive to compromise on the fee issue to satisfy the former client, and hopefully this doesn't go any farther.
And I think the mediator can use that, again, I think cautiously, but what happens if this doesn't get worked out here to counsel in a caucus? Where's this going? What's at risk? What do you want to do? But it's one more thing, it's on their mind.
I want my $3,700.
That's not what I offered you. All right.
Thank you all so much. Appreciate it.
I thought the lawyer moved awfully easily over to his figure, but had he had stonewalled and said, I'm entitled to my entire fee, in the caucus, I might have, with the client, said, if you think that you're entitled to a refund for this amount, what is it that he didn't do that entitled you to that money back?
Right.
Or is there something about what he did that makes you feel like you're entitled to it back? But he went to the figure real quick, so now it's a matter of how do we pay it? But again, for the various nuances. And then in a private meeting with him, where do you go from here if this doesn't resolve? So he's got some pressure on his back as well.
Now, you make an offer. If you skip the bottom BS and you get him either side to make a significant offer that your client approves, you're going to go, that mediation is going to go very quickly, and everybody's going to sit down together.
But I'm just saying, just in the event he doesn't move that quickly.
So,
you see, he was conciliatory. He wants that much? Okay, now, how do I pay him? I got to broke him back.
Yeah, you know why? Because I loved hearing 11 to 14,000 in the beginning. And we had 20 minutes
Thanks
left.
a lot.
So. Thank you, everybody.
Thank you all.
Cocktail hour.
Done.
Thanks.
Good job. Appreciate it.